Good morning. I don't know how to make my flip-flops extra flip-floppy, but I hope they're extra flip-floppy for you today. Most people, when they're children, that was really weird. Most people, when they're children, they learn by being disciplined that if you throw a tantrum to get your way, you're not going to get your way. And there's a reason for that. We don't want to encourage people to throw tantrums. Parents don't want to encourage their children to grow up into adults who throw tantrums. Now, I realize that sometimes tantrums do get you your way in today's day and age, but what are you going to do? Hashtag not all. Anyway, apparently yesterday we had a group of, I'm going to use the term loosely, but adults outside of Denver courthouse throwing a tantrum. Now, these guys are legal geniuses who have an issue with the executive branch, fuck the police, and the legislative branch, the judicial branch, the people who enforce the laws, and the people who interpret the laws. What they don't realize is that their issue is with the laws. Now, agree with them or disagree with them, their issue is with the laws. Who writes the laws? Who can change the laws? These dumb fucks don't realize that all they have to do is get the legislative branch in Colorado to change the laws. They just write new ones. It's as simple as that. Of course, people don't like this group of ragtag tantrum throwers who are unwashed, unkempt, uncouth. And so they never will get the legislative branch to change the laws. So one of these legal geniuses comes out of court having lost his case. Of course he blames the public defender, because but for that silly public defender, that know-nothing public defender, not using all of his evidence. He had mountains of evidence, mountains of it. So much evidence, overwhelming amounts of evidence. If she'd only used his evidence, he would have won, don't you know? Well, I hate to break everybody's hearts, but I'm going to say probably not. Probably not. Most likely not. See, there's a reason why lawyers exist. And by the way, Two Truth for Liberty is not a lawyer, nor is Rappin' Boomer, nor is Right to Record. But there's a reason why attorneys and lawyers exist. And that's because they know the rules. They know the rules. They know how to play the game. They know what you can bring into evidence and what you can't. I haven't looked this up, but I'm going to assume, since there are federal rules of evidence and there are California Evidence Code and there's the Texas Evidence Code, I'm going to assume that there is a Colorado Evidence Code of some sort that says what you can and what you can't bring into evidence. And I'm sure it's going to be fairly close to the federal rules of evidence. And so things like hearsay are excluded. Now, if you have made a video where you're talking in the video and you get busted on some charge, I literally don't know what charge Liberty Freak got charged with, and I also don't watch his videos, so we're just making assumptions at this point. But if you've made a video where you have talked to the camera and explained things, and you want to introduce that into evidence, the other side gets to say, no, I object, that's hearsay. And there are lots of things like that. On the other hand, though, on the hearsay side, the other side can bring that very same video in. Because that is a declaration by a party opponent. Anyway, but my point is that Number one, your mountain of evidence has to be relevant. The attorney isn't going to waste the court's time with a mountain of irrelevant evidence. 20 years of your bank statements isn't relevant to a battery charge or whatever the fuck he's in there for. So there are lots of issues there. But my point is that this idiot probably doesn't know the first goddamn thing about what is or isn't relevant and what the Colorado Evidence Code looks like, or what it says, or how to interpret it, or how it's been interpreted. I thought there was one more thing I wanted to say. I guess not. Maybe I'll think of it later. Thanks for watching. Have a great day. Oh yeah, I finally remembered what the final thing I was going to say is. The other legal geniuses who had to remain outside, number one, were not held out there in violation of the Sixth Amendment. The right to a public trial doesn't mean that the judge has to allow a rowdy group of people in there who are going to disrupt the court. Nowhere in there does it say that. The court can close the hearing if people are being disruptive, or if there is a genuine and palpable threat of people being disruptive. So that's not a violation of the Sixth Amendment. And the final thing is, I wonder to myself if these people truly think that they were helping that Liberty Freak TV guy by being out there acting like assholes, because they were, of course, intimately associated with him. He is their little, or they are his little vigilante squad. But you can be assured that the judge was aware of it. And I doubt seriously that the judge or anybody else was especially taken by that. So that's not a good legal strategy. Thanks for watching. Have a great day.